After a Wall Street Journal report on the relationship between Donald Trump and Jeffrey Epstein, the president is now asking the DOJ to release any pertinent grand jury testimony from this case. Joining us now is former U.S. District Court Judge Shira Scheindlin. Judge, great night to have you. Thank you very much for being here. We were just discussing what would a judge do. So what do you think? I mean, how hard is it to release grand jury testimony?
Well, there's a high bar, but it's not hard in the sense that the judge looks at it, the judge decides whether it's pertinent. But the question I had is listening to you, pertinent to what? What are we talking about here? Pertinent to what is the big question. I think that's what Judge Berman, Richard Berman, who was my colleague for many years, that's what he's going to be thinking. Now what is it pertinent to? Look, it seems to me, and I didn't hear all of this earlier conversation, but this is a self-made problem. The Republicans campaigned on releasing it all because it was a big conspiracy, and they were going to let it come out so the public would know. And all of a sudden, when it's time to come out, after the Attorney General said it's on my desk, suddenly there's nothing there to release. So there's certainly a public interest on one side, but there's a privacy interest on the other. There are witnesses, there are victims. That could be redacted, so you could release some statements and redact others, which means black them out. For people who didn't know what redact means, you can take things out and release it in that form. So if I were a speculating person, I think something will get released of the grand jury minutes. Now, I think, as I heard on the last segment, most of the material is not grand jury material. So there's still a decision that somebody's making to release or not release. And that's not up to the judge.
Can I ask a question of the judge? In a case like this, does the court have to give an opportunity for people who may be mentioned in that transcript to come and object to this?
No, I think the judge would consider that privacy interest and would probably redact. Look, the person at the center of it is dead. Yeah. We have to recognize that. This is in a way such old news, but it's self-made harm. It's self-inflicted.
What marks pertinence? They said that's the key question.
I said
what
that.
do you weigh there?
No, I don't know, because I'm not quite sure of the answer of pertinent to what.
Public interest. You raised the phrase public interest.
And there is also Ghislaine Maxwell, who is
That's
alive.
True.
She's not
That's
dead.
true.
And she is in prison because of her role in
Well, she has a case pending before the
Supreme Court. Well,
so could she object to it, saying it could hurt my case?
She could, but they haven't taken her case. I think it's a cert petition. I don't know that she's agreed yet to hear this appeal. It would be unlikely, frankly, that they would take it. What's the legal issue that's of interest to the court? So,
and you mentioned that there are people that could. Maybe this is not released because the people still have to be protected. But what about the president of the United States? Obviously, Jeffrey Epstein is dead. Yes, the person who is at the center of this case. But if it involves the president of the United States, the sitting president, how does that impact what's released?
If there's something in the grand jury testimony that might in some way impact him, that's something that the judge would have to consider in both directions. In other words, does the public have a right to know what his involvement was? I mean, we seem to know an awful lot about it already, right? We've seen his picture every night as a young man with Jeffrey Epstein. We now hear his letters, his birthday cards, or all the rest of it. So we know a lot about their relationship.
With us now, CNN senior legal analyst Elie Honig. The president tells the Attorney General Pam Bondi to ask a court for the release of pertinent grand jury testimony. Why is the word pertinent important here, Elie?
Well, pertinent's doing an awful lot of work there, John. First of all, just grand jury testimony itself is only going to be a fairly small fraction of the entire file. In addition to that, we now have this word pertinent. And so that begs the question, pertinent to what? And pertinent as determined by who? So it gives the Attorney General, in some respect, wiggle room, but it also puts her in a very difficult position where apparently she's going to have to A, decide what's pertinent, and then B, you have to go in front of a federal judge and get permission to release grand jury materials. So there's a lot of hurdles still in place here.
What is the difference between calling for the release of pertinent grand jury material and calling for the release of all investigatory information in the Jeffrey Epstein case, which is what some Republicans and the president's own supporters have long been calling for?
So there's a massive difference there, John. So if you think of the entire file here, and by the way, we know from last week's FBI memo that this is a huge file, 300 gigabytes of information. That's millions and millions of pages of documents. You can sort of separate it into two perceptual categories. There's grand jury materials. Those are presumptively confidential. By law, you cannot turn them over to the public as a prosecutor unless you get a judge's permission first. But then there's all the rest of it. That's something that the president, the attorney general can decide on their own without going through a judge first and say, I'm going to release this. And so what the president has done here is said, I only want to focus on the narrow category, the grand jury stuff, that you first have to go to a judge for. As to all that other stuff, the majority of the file, that is entirely up to the AG and the president. If they want to release that today, they can do that.
Okay, wow. I want to make that even more clear. What the president has now publicly called for is for the attorney general to push for the release of stuff that they can't control the release of. A court can. What he's not calling for is the release of information that he and the attorney general can control?
Exactly. So when you think of a file, you have your grand jury materials. Actually, you typically store your grand jury materials in a physically different colored folder because you need to set that aside because that's the confidential stuff. So all the stuff that's in a red or yellow folder, all the grand jury materials that has to go through a judge, that's what Donald Trump is saying, I want you to ask a judge to release. But then the bulk of the file is going to be everything else, everything that is not grand jury testimony. All of that is within Donald Trump, is within Pam Bondi's discretion to release. Now, of course, they'd have to make all sorts of determinations about it. They'd have to redact out to protect victims and witnesses and minors. And by the way, ordinary DOJ procedure is you would never release any of this. This is a closed case investigative file. Try to serve a Freedom of Information Act request on DOJ for any such file and watch how quickly they reject it in the ordinary course. So Trump and Bondi are already painting way outside the lines here. But yes, John, the specific portion that Donald Trump has said, I want you to try to release, that also happens to be the exact portion that a judge has to sign off on first.
And this is something that judges very rarely release. It's something that you have to jump through a lot of hoops to get out there. Elie Honig, great explanation. Thanks so much for coming on this morning.
Let's take a closer look now at the letter that's in the spotlight. Here is the Wall Street Journal reporting, and it is very, very graphic. The article describes the letter this way, and I'm quoting now from the Wall Street Journal. Quote, it contains several lines of typewritten text framed by the outline of a naked woman, which appears to be hand-drawn with a heavy marker. A pair of small arcs denotes the woman's breasts, and the future president's signature is a squarely Donald below her waist, mimicking pubic hair. The letter concludes, and again I'm quoting from the Wall Street Journal, happy birthday, and may every day be another wonderful secret, close quote. Let's go live right now to CNN's chief legal affairs correspondent, Paula Reed. Paula, the president says he will sue the Wall Street Journal and its owner, Rupert Murdoch, the media mogul that Trump has seen as both an ally and at times a foe. How difficult of a case would this be for the Trump lawyers?
Well, it'll be interesting to see, Wolf, if he actually follows through with this lawsuit or if he's just blowing off steam. But we know it is much harder to prove a case in court than it is to, these days, extract settlements from news organizations that have whatever reason for wanting to just resolve a situation. We saw that most recently, of course, with my former employer, CBS News. They faced a lawsuit from Trump that was widely discredited and thought to be frivolous, but they still settled it because they had their own reasons for wanting to make that go away. And that is something, especially because Trump has had success with multiple media outlets extracting settlements that might embolden him to file a lawsuit here, even if he's unlikely to win. Now, look, you, me, Pamela, Elena, we have all worked at the White House. We know what it's like when they want to bury a story, the kind of pressure that you face. So the Wall Street Journal deserves credit for following through with its reporting that it's clearly confident in, even in the face of these threats and that pressure.